Welcome back, everyone, to criminal law. The topic of today's recording is causation. Causation is a fascinating topic, and it's also a challenging topic that impacts many different areas of law. One of those areas you may already know something about, the law of torts. As former tort students, I'm guessing you've already learned how causation can impact civil negligence claims and other forms of tort liability. Another area where causation is important is the criminal law. In this context, causation plays an important role in determining criminal liability for all offenses which incorporate a result element. As a result, causation constitutes our fourth fundamental element of criminal liability, following our discussions of the voluntary act, mens rea, and social harm. For those of you coming into today's recording with some background knowledge of causation from your torts class, that's great, because there are definitely some similarities between the two concepts. At the same time, there are also some specific differences between civil and criminal causation, which reflect broader differences between the areas of law that they're a part of. Whereas torts is focused on civil compensation and places high priority on economic interests, the criminal law deals with punishment and moral condemnation. With these general policy differences comes specific doctrinal distinctions. As a result, the criminal law's approach to causation doesn't perfectly mirror the civil law's approach. So for this lecture, I'm going to ask you to gently place what you may have previously learned aside as we explore the criminal law's approach to causation. Specifically, in today's recording, we're going to explore how causation provides an essential link between the general requirement of a voluntary act and the social harm required by result element crimes. So for example, assault requires a result element of bodily injury, homicide requires a result element of death, and destruction of property requires a result element of destruction. To secure conviction for one of these offenses, the government must generally prove that the defendant engaged in a voluntary act and that the harmful result prohibited by statute actually occurred. Those elements are necessary ingredients of criminal liability, but they're insufficient ingredients, because the mere occurrence of a voluntary act and social harm are not enough to support criminal liability for a result element offense. Instead, there must also be a sufficient connection between the voluntary act and the social harm which supports attributing the latter to the former, which is to say, the connection between the voluntary act and social harm must be strong enough that the harmful result is fairly attributable to the voluntary act. In today's recording, we're going to study two aspects of that connection: factual causation and proximate, or what we'll refer to today as legal causation. Each is part of the government's burden of proof, so both have to be established beyond a reasonable doubt. Viewed together, these two components provide the basis for determining whether a given social harm is fairly attributable to the defendant's conduct, in contrast to other people or forces in the world for which the defendant just isn't accountable. Okay, so there are three main learning objectives for today's lecture. First, I'm going to introduce you to the topic of factual causation, beginning with the easy cases, and then transitioning to the more difficult ones, where multiple forces in the world simultaneously contribute to a single harm. Second, and thereafter, I'm going to introduce you to the topic of legal causation. In so doing, we're going to focus on two central principles of causal responsibility: the requirement of reasonable foreseeability and the requirement that a harm not be too dependent on the volitional conduct of someone other than the defendant. Third, and finally, we're going to discuss the realities and limitations of causation doctrine. In the process, we're going to explore where the criminal law of causation comes from, how to codify it, and why the model penal code approach to codifying causation has had minimal influence on US criminal law. Sound good? I hope so. So with that, let's dive in. Let's start with the requirement of factual causation, which is the first and more empirical of the two components of causation we're going to discuss today. Simply put, factual causation requires that the defendant's conduct be a but-for cause of the result, meaning that if the actor's conduct had not occurred, the result in question also would not have occurred when it did. To answer this question of whether factual causation exists, you have to engage in a counterfactual analysis that is fundamentally scientific, but also hypothetical. That is, you have to imagine what the world would have been like if the actor had not performed their conduct, and then ask whether it would basically look the same, which is to say, you have to ask, would the result prohibited by statute and suffered by the victim still have occurred when it did? For this reason, people often refer to factual causation as but-for causation. The idea here is that but for the act, the result would not have taken place when it did. So look, for philosophy majors, this kind of logical principle might seem simple and intuitive. But for the rest of us, thinking this kind of abstract, counterfactual way can seem a little awkward, at least at first. So let's take it slow, starting with some easy examples. Consider first a simple case where factual causation is met. You want to kill me, so you bring a loaded gun to class, point it at my head, and then pull the trigger. You shoot the bullet into my head, and I die within seconds of impact, just as you'd hope would happen. Now you find yourself in court being prosecuted for purposeful murder, which prohibits purposely causing the deaths of the human being. Under these circumstances, factual causation exists and should be relatively easy for the government to establish. Because here, your voluntary act, that is, deliberately pulling the trigger, is the factual cause of my death, because but for your pulling the trigger on the gun, I wouldn't have died when I did, namely, right after you pulled the trigger. Okay, so that's an easy case where factual causation is met. Now let's consider a situation where factual causation can't be met. For this, I want you to imagine the same facts as before, except now your leg cramps right before you pull the trigger of the gun, leading you to fall as you shoot. As you're falling, you miss me entirely. But at the same moment the bullet's whizzing by, I die from a completely unrelated brain aneurysm. Now, once again, you find yourself in court being prosecuted for purposeful murder. Under these circumstances, there is a voluntary act and the social harm of death. However, you can't be found guilty for murder because factual causation is absent. Specifically, your voluntary act of deliberately pulling the trigger isn't the factual cause of my death for the basic reason that our counterfactual test isn't satisfied under the circumstances. Simply put, even if you didn't pull the trigger on your gun when you did, I still would have died when I did. As a result, it was my neurobiology and not your voluntary act which is empirically responsible for my death. And because your conduct didn't in any way contribute to or hasten my death, you can't be deemed its factual cause. Okay, so those are a couple of simple cases. Before we march any further, I want to pause to note an important policy point, which you'll want to keep in mind. In most cases, causation is really about the amount of punishment someone receives, rather than whether they get any punishment at all. Which is to say, just because causation is absent doesn't usually mean the person gets off. Instead, the absence of causation typically only precludes criminal liability for the completed version of a result element offense. In most cases where causation is the only element missing, it'll still be possible to convict the defendant of a criminal attempt or some other inchoate version of the charged offense, which doesn't require proof of a result element. So for example, in the last hypothetical, where you missed your shot and I died of an unrelated brain aneurysm, you couldn't be convicted of murder due to the lack of factual causation. But you still could be convicted of attempted murder, giving your purpose to kill. We'll spend a lot more time exploring what this means later on this semester when we study inchoate crimes. But for now, I just want to note that there's usually a pretty significant difference between the penalties for completed murder and attempted murder, as is often the case throughout the criminal law. As a result, the practical impact of causation may be less world-altering than, say, completely avoiding criminal liability due to the absence of mens rea. But at the same time, the stakes are real and significant, and so causation is an important part of criminal law analyses. So with that, let's now get into some harder cases involving factual causation. The factual causation analysis is easiest where the causal chain between the act and result are direct, as we saw in the first illustration. However, even when other forces intervene, factual causation is still easy to meet, or at least it can be. Consider the following scenario. Dina initiates a gun battle with Xavier. Xavier then returns fire in self-defense, but mistakenly hits a nearby bystander, Victoria. Under these circumstances, Dina is still a factual cause of Victoria's death, notwithstanding Xavier's intervening act. But why? Well, simply put, but for Dina's initiating a gun battle with Xavier wouldn't have returned defensive fire, and therefore Victoria wouldn't have died when she did. So far so good? I hope so. Now let's consider the complications presented by a phenomenon known as concurrent causes. These are multiple causes which simultaneously contribute to the same result. As we'll see, concurrent causes are a basic fact of life and of death, even where it occurs naturally. So for example, imagine that Terry dies of a heart attack on April 30th induced by long-standing stress, a lifetime of smoking, and complications from a recent COVID infection. Take away one of these three concurrent factors, and Terry wouldn't have died when he did. As a result, each is a factual cause. The same analysis applies to concurrent harms caused by human actors. Here's an example. David shoots Vilma in the abdomen. based on this wound alone, Vilma would have died from loss of blood in 2 hours. But at precisely the same time, Dante, who was not acting in concert with David, also shoots Vilma in the back. Based on this wound alone, Vilma would have died from loss of blood in 5 hours. But due to the combined effect of these wounds, Vilma dies in 1 minute. Under these circumstances, both David and Dante are factual causes of Vilma's death for the same reason we've been discussing. Without David's conduct, Vilma wouldn't have died when she did. And without Dante's conduct, Vilma wouldn't have died when she did either. Because each actor's conduct accelerated death, both are considered to have factually caused it. So this fact pattern reflects a general principle of concurrent causation. If there are 2 or more concurrent causes, and each is necessary to the timing of the social harm, then all are factual causes. So with that, let's go one step further and consider the tricky but incredibly rare situation of 2 or more concurrent causes, each of which is sufficient to bring about a harm when it occurred. Here's an illustration. Dinesh and Dahlia don't know each other, but they have something in common. Both wake up on January 1st, 2024, and decide separately that they're going to kill Vernon at 3 p.m. on the sidewalk where he normally walks his dog. At 3 p.m., both Dinesh and Dahlia approach Vernon from opposing sides of the street and fire their gun at Vernon's head at the same time. Both bullets are on target, and each would be independently sufficient to immediately kill Vernon at 3:01 p.m. Under these circumstances, neither actor appears to be a factual cause based on the principles we've been learning so far. Because if you subtract one person's conduct from the equation, the result remains the same. Vernon dies when he did. And yet, here the outcome of standard factual causation analysis is less than satisfying. To say that neither Dinesh or Dahlia can be held liable for murder under these circumstances seems morally problematic. So, in response, the criminal law says that factual causation does exist by using a conceptually problematic solution, what's called the substantial factor test. This test is less of a test and more of a declaration. It basically says that in these types of rare situations, anyone whose conduct was a substantial factor in bringing about the result counts as a factual cause. Precisely how the conduct of someone involved in a situation where someone else simultaneously does something independently sufficient to cause a required harm counts as a substantial factor, well, that's never really explained. All the law tells us, and all that you need to know in this class, is that this magic language supports the most intuitive outcome in exceedingly rare situations which involve concurrent sufficient causes. And that, my friends, is factual causation in a nutshell. In all but the most exceptional cases, factual causation requires proof that the harmful result prohibited by a criminal offense would not have occurred when it did, but for the defendant's voluntary act. Factual causation is a necessary element of liability in the sense that the government has to prove its existence beyond a reasonable doubt in any prosecution involving a result element crime. And yet, while factual causation is a necessary ingredient of liability, it's not sufficient. That's because sometimes, even where the defendant's voluntary act is a factual cause of a harm, other forces may intervene in such a powerful way that it would seem unjust to blame the defendant for causing that harm. Here's a simple illustration. Listen to this sound. That's super annoying, right? Yeah, good. Now I want you to imagine that this super annoying sound leads whatever device you're using to watch this lecture to explode for a completely bizarre and unpredictable reason. That explosion in turn leads you to jump out of the way and tumble into a large boulder that happens to be resting near you. So your contact with the boulder leads that boulder to tumble down the street or hallway and then fatally crush another human being, causing their immediate, though fortunately painless death. So in that case, my annoying noise would be a factual cause of this innocent victim's death, because but for my being alive and putting together these asynchronous lectures, your device would have never exploded. And my parents would also be a factual cause of this innocent victim's death in the sense that but for their decision to conceive me, I wouldn't be alive today teaching you. And so on and so forth, going all the way back to the Big Bang. You get the idea. If the criminal law is ultimately about blame, then clearly something more than factual causation should be necessary for criminal liability. Fortunately for me in this situation, as a matter of policy, something more is necessary. The second component of causation, what's called proximate causation, or what I'll refer to in this lecture as legal causation. In a minute, we're going to be learning some specific legal causation rules. But before we do so, I want to honestly acknowledge what legal causation is and what it's fundamentally about. Legal causation is, in short, a collection of our intuitive judgments about when a harm that the defendant factually caused can fairly be attributed to the defendant, given the manner in which the harm occurred and all the other forces in the world that may have contributed to its occurrence. In this sense, legal causation is a matter of empirical verification, as we saw with factual causation. Instead, legal causation is ultimately about justice. As a result, we don't discover the legal cause of harm. Rather, we select the legal cause of harm based on our sense of fairness and moral responsibility. And that brings with it an inherent level of subjectivity, as you'll come to see in this recording. In the discussion that follows, I'm going to present you with two general principles which do a pretty good job of making sense of the results reflected in this area of the law across jurisdictions. And for purposes of the exam, those are the only two principles you need to know as a matter of legal causation. At the same time, I want you to keep in mind that in the real world, the law of legal causation can be chaotic, confusing, and unpredictable. So if you ever find yourself practicing in this area of law, you want to pay careful attention to the specifics of the jurisdiction you're working in. Hopefully, what you'll learn today provides you with the foundation that you need to succeed and to navigate the complexities you may confront. Okay, so with that disclaimer being laid out, let's now try to impose a little order and understanding together. Let's start with the basics. So, legal causation issues only arise once intervening outside forces come into play. If you see a fact pattern without those forces, well then legal causation is unlikely to be an issue. By contrast, when intervening outside of forces arise, the question becomes whether any of them qualify as a superseding cause, sufficient to break the chain of legal causation. The fundamental question to ask in determining whether an intervening cause is a superseding cause that breaks the chain of legal causation is whether it was reasonably foreseeable. Generally speaking, if the intervening causes were reasonably foreseeable, then there's no problem with attributing the result to the defendant's conduct. By contrast, if the intervening causes weren't reasonably foreseeable, then they're typically viewed as superseding causes of the social harm, which break the chain of legal causation. Okay, so there are no hard and fast rules for working through the basic question of reasonable foreseeability. Ultimately, what counts as reasonably foreseeable hinges on the intuitions of legal decision makers. At the same time, many courts find it helpful to think in terms of responsive and coincidental intervening causes. And so that's what we'll practice doing in this class. A responsive intervening cause is an act or force that occurs in response to the defendant's prior wrongful conduct. Here's an example to illustrate. David shoots Victor, an innocent victim, in the leg while both are standing on the sidewalk. Now imagine a variety of potential things that might occur in response. Perhaps an injured and frightened Victor runs into the street to avoid being shot again. Or perhaps Victor is frozen in shock and pain when a nearby bystander tries to stem the bleeding on Victor's leg. Or perhaps an EMT drives Victor to the hospital where he's operated on by medical personnel. These responsive intervening causes present a challenge to causation analysis when they aggravate rather than mitigate the harm caused by a culpable actor like David. So for example, imagine that Victor runs into the street and then tumbles over a bridge to his death. Or that the Good Samaritan or medical personnel treating David inflicts a fatal wound in the process of treating him. Or imagine that David has an eggshell leg and thus experiences far greater harm from being shot in the leg than your average person. Or what if David, having experienced the misery of being unable to walk as a result of the injury, decides to take poison to end his misery? Under these circumstances, and those like them, the criminal law says that a responsive intervening cause is presumptively foreseeable and thus does not break the causal chain unless it's highly abnormal or bizarre. The underlying rationale for this rule is simple. Because the defendant is responsible for the presence of the responsive intervening force in the first instance, it's fair to hold the defendant liable for the harm caused by that responsive intervening force, unless it was so out of ordinary that it would be unfair to hold the defendant liable for the harm. The criminal law's general approach to dealing with situations of medical malpractice is illustrative. For example, imagine that in response to being shot in the leg by David, Victor is brought to the hospital and operated on by Dr. Dino, who is severely underslept and overworked, as is often the case for emergency room doctors. Unfortunately, things don't go as planned. In the process of trying to quickly remove the bullet, Dr. Dino slices open a vital artery on Victor's leg, thereby causing Victor to die from blood loss. Under these circumstances, Dr. Dino's medical malpractice is a responsive intervening cause and therefore presumptively foreseeable. Moreover, Dr. Dino's conduct is not highly abnormal or bizarre. Indeed, the criminal law views ordinary medical malpractice like Dr. Dino's as reasonably foreseeable because of how pervasive it is, even if it may be statistically improbable for any particular operation. But look, this analysis changes in situations involving grossly negligent medical malpractice. Imagine, for example, that Dr. Dino is drunk, high, and in a state of complete emotional shock when he conducted Victor's operation, which happened right after he lost his child in a fatal car accident. As a result of his chaotic state of mind, Dr. Dino inadvertently slices open arteries on Victor's neck, which was multiple feet away from the gunshot wound Dr. Dino was supposed to be operating on. Under these circumstances, Dr. Dino's grossly negligent medical malpractice is a responsive intervening cause. But it's also highly abnormal or bizarre and thus unforeseeable. As a result, Dr. Dino's grossly negligent medical malpractice would supersede or break the chain of legal causation. Okay, so that's how the criminal law deals with responsive intervening causes, which again involve reactions to conditions created by the defendant. These are to be distinguished from coincidental intervening causes, which are acts or forces that don't occur in response to the initial wrongdoer's conduct. So for example, imagine that Victor, after being shot by David, runs into an alley to avoid being shot again. Then, while hiding in that alley, Victor is randomly hit by lightning or killed by a tornado. Under these circumstances, and those like them, the criminal law says that a coincidental intervening cause is presumptively unforeseeable, and thus does not break the causal chain unless it's foreseeable, all things considered. Both this general principle and the caveat make good intuitive sense. In most situations where the defendant's primary contribution to the victim's harm was merely to place them in the wrong place at the wrong time, well, then we tend to view the coincidence as unforeseeable and thus falling outside the defendant's moral responsibility. So for example, imagine that Dina hits Vilma with her car, and as a result, Vilma is lying on the side of an isolated road in the mountains injured. Then an earthquake swallows up Vilma, or a mountain lion eats Vilma, or a murderous scavenger in the area shoots Vilma. These intervening causes are coincidental, and therefore supersede or break the chain of legal causation because they are reasonably unforeseeable. So that's to be contrasted with situations involving coincidental causes that are also foreseeable. So for example, if Vilma is hit by another driver on the road, or by a boulder in a mountainous area where rocks fall routinely, well then Vilma's death would not at all be surprising. And thus, even if these intervening forces are coincidental, they wouldn't supersede or break the chain of legal causation, since they're entirely foreseeable under the circumstances. Does that make sense? I hope so. Okay, so at this point, I hope you're able to appreciate how reasonable foreseeability is the foundation of legal causation analysis. Generally speaking, a person cannot be deemed the legal cause of a harm unless that harm was reasonably foreseeable. And in most situations, where the resulting harm is reasonably foreseeable based on the defendant's conduct, the defendant will also be deemed its legal cause. But, as is so often the case, there are exceptions. One important exception, which we'll focus on in this class, specifically applies to situations involving intervening human forces. Sometimes, the criminal law breaks the chain of legal causation where the occurrence of a result is too dependent upon the influence of a free, deliberate, and informed intervening act of another human being. And that might be the victim or a third party. This is also true even where the occurrence of a result was foreseeable under the circumstances. Because sometimes, even when the aggravation of a harm by another human being may be foreseeable, the mere fact of human intervention through a voluntary, knowing, and intelligent choice can break the chain of legal causation. To illustrate the operation of this principle, let's begin with the simplest situation, where the intervening human conduct is both unforeseeable and volitional. Consider, for example, the following facts which I mentioned earlier. Dina hits Vilma with her car, and as a result, Vilma is lying on the side of an isolated road in the mountains injured. Then a murderous scavenger comes along and shoots Vilma. One reason to break the chain of legal causation under these facts is because the murderous scavenger's conduct is a coincidental intervening cause which was entirely unforeseeable. That is, on the facts I provided you with, there's no reason for Dina to think hitting Vilma and then leaving her on the side of the road would make her more susceptible to the machinations of a murderous scavenger. But there's also another reason to break the chain of legal causation. Because Vilma's death is too dependent on the influence of the murderous scavenger's free and deliberate informed decision to murder Vilma. So then, under these circumstances, there are two independent bases to break the chain of legal causation: the absence of reasonable foreseeability and the presence of volitional conduct. Now I want to tweak the facts so that you can see the impact of the volitional conduct principle even where reasonable foreseeability is present. Imagine, for example, that Dina hits Vilma, not in a mountainous area, but in a high crime neighborhood where robberies are well known and rampant. As it turns out, the members of a local gang looking for a robbery opportunity see an injured Vilma lying on the ground 30 minutes after the initial accident and take advantage of her vulnerability, robbing her of all of her valuable belongings while she's on the pavement. In the process of conducting that robbery, the gang inflicts a significantly more serious injury on Vilma than she originally suffered from getting hit by Dina's car. Under these circumstances, is Dina the legal cause of the robbery or the aggravated injuries? The answer is no, she's not. Under these circumstances, it may be reasonably foreseeable that an injured Vilma, vulnerably lying on the side of the road, would experience a violent robbery. But that robbery was the product of the gang's free and deliberate informed decisions to steal and perpetrate violence. As a result, that decision is the legal cause of the robbery and aggravating injuries, and not Dina's bad driving. Dina is, of course, the legal cause of Vilma's original physical injury resulting from impact with her car, and for that she can be held criminally responsible. But under these circumstances, the later harms are too dependent on the volitional conduct of the gang, and that would break the chain of legal causation. For another illustration, let's consider a recurring example you'll encounter in your reading: the injuries or fatalities suffered by the co-participants in a drag race. So whenever two or more people drive at extremely high rates of speed in metropolitan areas, there's a really high risk that one of them will injure or kill themselves in the process. So when one participant is harmed or killed in the process, that's a foreseeable consequence of the other participant's conduct. And yet, under these circumstances, courts generally decline to hold the co-participants causally responsible under the volitional conduct principle. Undoubtedly, the co-participants in our drag race are a factual cause of the harm suffered by another one of the participants. But for their participation, that harm would have never occurred. And again, that harm is reasonably foreseeable. And yet, because the injured drag racer made a free, deliberate, and informed decision to participate, their volitional conduct is understood to break the chain of legal causation. Okay, so far I've given you two illustrations of the volitional conduct principle, which involves intervening criminal conduct. But it's important to note that the intervening conduct doesn't have to be criminal to break the chain of legal causation. Consider the following situation, which is based on a real-world case. Danny threatens the life of his wife, Valentine. As a result, Valentine is forced to leave their house on a bitterly cold night to protect herself. Valentine then walks to her parents' house. But once she's outside, Valentine decides not to ring the doorbell. She thinks rather than bother her parents, she'll just spend the night outside in the cold, the extreme cold. As a result, she freezes to death. Under these circumstances, Danny is surely the factual cause of Valentine's death. But for his threatening her, Valentine would have never been tempted to spend the night outside. And yet, Danny's not the legal cause of Valentine's death because Valentine chose to spend the night outside. That choice wasn't criminal, but it was a free, deliberate, and informed act sufficient to break the chain of legal causation. So far, so good? I hope so. With that, I want to highlight a point which might seem obvious, but is important to recognize. Where the intervention of another human, whether we're talking about the victim or a third party, isn't free, deliberate, or informed, well then this volitional conduct principle doesn't support breaking the chain of legal causation. To illustrate what I'm talking about, let's tweak the facts of the domestic dispute we just discussed. I want you to imagine that Danny began chasing Valentine with a knife in the second story of their home, leading Valentine to jump out of the window and fatally fall to her death in an attempt to save her life. Or I want you to imagine that Danny kept Valentine confined to a basement for an entire year, leading Valentine to take her own life with poison in a state of abject despondence. Under both sets of facts, Valentine's choices clearly played a huge role in her death. However, those choices were made under extreme and coercive circumstances. As a result, in neither situation would Valentine's choices be sufficiently free, deliberate, and informed to break the chain of legal causation. The same kind of analysis applies to the intervention of third-party conduct. For a simple illustration, return to the shootout scenario I mentioned at the beginning of this lecture. Dina, a notorious criminal, initiates a gun battle in an alley with Xavier, an innocent individual that Dina believes to have snitched on her. Seeing no means of escape, Xavier, who happens to be armed, returns fire in self-defense, but mistakenly hits a nearby bystander, Victoria. Under these circumstances, Dina is still a legal cause of Victoria's death, notwithstanding Xavier's intervening act, because Xavier's intervening act wasn't voluntary. Simply put, when bullets are flying at someone, and that person reflexively responds to save their own life, well then there's nothing free, deliberate, or informed about that response. For a final illustration of this idea, let's return again to the domestic violence scenario. Now I want you to imagine that Danny begins chasing Valentine with a knife on the first floor of their home, leading Valentine to sprint outside and onto oncoming traffic to escape Danny. As she's running into the street, Valentine's loving mother, Beatrice, happens to be driving by. Beatrice sees the horrifying scene unfolding before her, freezes, and so fails to swerve out of Valentine's way, thereby tragically killing her own daughter. Under these circumstances, legal causation exists for 3 reasons. First, Beatrice's failure to swerve out of the way is likely an omission. And the general rule is that an omission by a third party will never break the chain of legal causation, even where the third party is under a legal duty to act. Second, the possibility that Valentine would try to escape by running into the street and that a driver might freeze in the moment when confronted with such a horrifying scene is reasonably foreseeable. Third, and perhaps more fundamentally, neither Valentine's decision to run to the street nor Beatrice's failure to turn her vehicle or swerve out of the way were free, deliberate, and informed in the way we've been discussing. Instead, these were acts or non-acts which were guided by instinct, fear, and shock. As a result, neither is sufficiently volitional to break the chain of legal causation. And with that, we've now reached the end of our substantive discussion of legal causation. Now I'd like to transition to some procedural issues that I suspect may have been nagging at you throughout this lecture. Where are the statutes, Professor Sirota? Why haven't you said anything about the Model Penal Code? And where exactly does the law of causation come from after all? Great questions. As with all the elements of liability we've covered in this module, the requirement of causation in criminal cases is a long-standing principle reaching far back into the common law. But by contrast to many other elements of liability we've discussed so far, the common law is largely where the modern law of causation is stayed. One reason for this, and probably the most important reason, is that the Model Penal Code drafters attempted a wholesale reconceptualization of legal causation, which is incredibly complicated, unintuitive, and poorly drafted. I won't bog you down with the details, since you already have enough on your conceptual plate right now. All you need to know for purposes of this class is that the MPC approach to causation is rarely adopted, even in reform jurisdictions, and has had very little influence in non-reform jurisdictions. And that's so, again, because of the difficulty of what the MPC drafters proposed, not because codifying common law principles is or should be difficult. Indeed, just the opposite's true, as I'm now going to show you in a sample codification, which I think does a serviceable job of recapping much of what we learned today. Let's take a look at the following. Section A, causation requirement. No person may be convicted of an offense that contains a result element unless the person's conduct is the factual cause and legal cause of the result. Section B, factual cause defined. A person's conduct is the factual cause of a result if 1. The result would not have occurred when it did, but for the person's conduct, or 2, in a situation where the conduct of 2 or more persons contributes to a result, the conduct of each alone would have been sufficient to produce that result when it did. Section C, legal cause defined. A person's conduct is the legal cause of a result if 1. The result is reasonably foreseeable in its manner of occurrence, and 2. The result is not too dependent upon the free, deliberate, and informed conduct of another person to fairly hold the defendant responsible for it. Okay, that's a mouthful. What does this all mean? Well, Section A states the overarching principle we've been discussing in this recording. To hold someone criminally responsible for a result element crime, they must have caused the prohibited result. This causal requirement, as we've learned, has 2 components, factual causation and legal causation, both of which have to be proven beyond a reasonable doubt. At the heart of factual causation, which is codified in Section B1, is the idea that but for the defendant's conduct, the result would not have occurred when it did. So this basic counterfactual analysis will dispose of just about every situation involving multiple concurrent causes, save one rare exception. That's a situation where two or more people independently contribute to a result under circumstances where the conduct of each alone would have been sufficient to produce that result when it did. In that case, as subsection B2 clarifies, the law deems each actor a factual cause, in more or less the same way that the substantial factor test discussed earlier would. From there, section C codifies the two overarching principles of legal causation we've been discussing in this lecture. The first is the requirement of reasonable foreseeability, which calls into question the responsive and coincidental intervening causes analysis we carefully considered earlier. Specifically, a responsive intervening cause is presumptively foreseeable and does not break the chain of causation unless it's highly abnormal or bizarre, whereas a coincidental intervening cause is presumptively unforeseeable and so breaks the causal chain unless it's foreseeable, all things considered. As we then discussed, the requirement of reasonable foreseeability is a necessary but insufficient basis for finding legal causation. In addition, it must be proven that a result is not too dependent upon the free, deliberate, and informed conduct of another person to fairly hold the defendant responsible for it. This principle is codified by subsection C2 as an independent requirement of legal causation, which applies even where the requirement of reasonable foreseeability can be met. So this is, in short, a statutory codification of the common law causation principles we've been discussing in today's lecture. Before ending this lecture, though, I want to pause one last time to reiterate a point I mentioned at the beginning of the recording. The law of causation is more art than science, and it's a messy art at that. The principles and codification I provided you with in this recording are an attempt at reducing what most courts do most of the time to a reasonably streamlined approach that is both logical and intelligible. However, that approach isn't everything there is to say about the topic, let alone a mathematical guide to predicting what courts will do. But for purposes of this class, it's all you need to know and all that you'll be held responsible for. And for a topic that's really only implicated in outlier cases, I think that's more than enough. Okay, so with that, we've now reached the end of this recording. You're ready to do the reading class assignments, which I'll look forward to discussing with you soon. Take care and see you soon.